This is TWiT.
Apple versus Samsung one more time.
It just won't die.
One more time. So the Supreme Court sent it back to the lower courts. Judge Lucy Koh says, we're going to do it a fourth time. This is the Apple versus Samsung trial over the is this the trade dress or the action?
I believe there's several. There was a design patent, yeah, and there was trade.
There's trade
One
dress.
of my
and
favorite
design.
Twitter accounts, Counter Notions Contra on Twitter, keeps tweeting like Judge Lucy Koh orders Eddie Q to take the field in Warriors game, just because she comes up with really great things for Apple to do all the time.
The long-running litigation, I'm reading from Ars Technica's story, Joe Mullen. The long-running litigation roller coaster has included so many turns it's hard to keep track. The case was filed in 2011, 6 years ago. Went to trial, a jury trial in 2012. That's when, remember, Apple won $1 billion. Then they had more post-trial hearings, and that was whittled down. And then there was a 2013 retrial for damages in front of another jury. Then the appeals court kicked out trademark-related damages altogether, leaving only the trade dress issues. Meanwhile, a second case moved forward in which Apple sued over a new generation of Samsung products. That went to jury trial in 2014. That resulted in a $120 million damage verdict. That verdict was thrown out on appeal, reinstated on subsequent appeal. Then the first Then the first case, Samsung said, all right, we'll pay you $548 million. Then the U.S. Supreme Court said, no, the damages was all wrong. But they didn't say how to do it right. They just sent it back. The High Court threw out the $399 million of the damages that Apple won. Not yesterday, but I think on Sunday, Lucy Koh published a 35-page order scheduling a hearing later this week in a whole new jury trial. It is the case that never ends.
I think it's the Apple's advantage for it to stay in
sauce for
court.
every American McDonald's customer.
Yes, Szechuan for everyone. Go ahead, Alex.
No, I think that it is it's an Apple's advantage to keep it in court for as long as possible, because it will affect thought processes on the other side. Because if you lose this for some reason, it could unravel to other things, and so I think they want to just keep them thinking about it all the time. That they and I don't know whether I think they've diverged enough at this point. I don't know if it really matters, but I'm sure they'll keep on taking this one as far as it'll go.
Yeah, Joe's article goes on and on, which I won't with details on what Koh's document said in terms of how it would be determined whether Samsung had infringed on Apple. She did say Apple should bear the burden of proof in determining the quote article of manufacture, which I think is a term of art for something I don't know what the hell it all means. But good Lord, fourth jury trial. And how much do you think these companies have spent on legal fees to this point? Not
More
a
than
billion,
most companies have.
a lot.
There's so many. It's getting to be like World War I, where people forget about both sides. They're just getting dug in deeper and deeper and deeper. And both have good sides to keep on going. I think Samsung's reason is because they did do some things they shouldn't have done, but also, and there's actually an illustration in that Ars Technica article that Apple is insisting that they own a black rectangle with rounded corners. And I like to say, no, you don't. It's I can just go into my closet right now and show you lots of products that predate the iPhone that are black rectangles with rounded corners.
Get sued. Don't do it, Andy.
Yep. It's hard to know. It's hard to pick a side to actually root for, because you feel as though both sides are being jerks, and that if this were a movie pitch, it would be that the lead lawyers on both sides are actually in love with each other, and this is how they keep the relationship going. I just want to keep seeing him. I just want to keep seeing her. What if we say that the damages should be prorated based on the trademark appeal in Canada as opposed to applied towards this? That'll give us an appeal, yes.